pressures, judges finally released reasons why Peter Obi lost to Tinubu at the September 6 Tribunal Judgment. Without prejudice to the above, the respondent avers that the Nigerian police force investigated the second respondent regarding any record of criminal arrest and conviction. The investigation was extensive and far-reaching. Consequently, the American Consulate, Lagos, Nigeria, revealed that there was no record whatsoever of any criminal arrest, warrants, and conviction regarding the second respondent. The respondent shall find and rely on the letter issued by the Embassy of the United States of America, Nigeria, dated 4th February 2003. Furthermore, the release from forfeiture of other monies in the account, the subject of the proceedings, in case number 93 C4483, in excess of $1 million, and for the benefit of the named beneficiary K.O. Tinubu, though not the account holder, less forfeited sum of $460,000 is a manifest affirmation that the case was not a criminal trial and the fund forfeited was not a fine imposed as a judgment for a criminal conviction of any person, let alone the second respondent. The disqualification factors as stipulated by the Constitution only conceives of a conviction sentence or fine involving dishonesty or fraud or contravention of the Code of Conduct as found by the Court of Law of competent jurisdiction or tribunal in Nigeria, it added. While urging the court to strike out petitions against Tinubu, the APC argued that Mr. Peter Obi of the Labour Party, who alleged that Tinubu was convicted for a drug-related case, lacks the requisite locus standi to challenge the outcome of the presidential election. Insisting that Obi was not validly nominated by the Labour Party, the APC stressed that he was not a member of the party at least 30 days before it conducted its presidential primary election. It told the court that Obi was a member of the People's Democratic Party (PDP) till May 24, 2022, adding that he was screened as a presidential aspirant of the party in April 2022. APC further averred that whereas Obi joined the Labour Party on May 27th, he was subsequently declared the winner of the presidential primary election the Labour Party held on May 30th, 2022. By Section 77 of the Electoral Act 2022, the second petitioner, LP, is mandated to have submitted its comprehensive register of members to the first respondent 30 days before its presidential primary. That is to say, the said register of members must have submitted to the first respondent on or before 30th April 2022. The first petitioner Obi, as at 30th April 2022, was still a member of the PDP and his name was not and could not have been in the register of members submitted by the second petitioner to first respondent, INEC. The petition hearing is incompetent as the first petitioner is not a member of the second petitioner since the first petitioner's name is not and could have been listed in the list of the register made available by second petitioner to the first respondent, same having been made available before the first petitioner joined the second petitioner. It therefore prayed the court to dismiss or strike out Obi's petition wholly or in part as may be.
Our clients are dissatisfied with the judgment just delivered. And we have the firm instruction of our clients to challenge the judgment on appeal. And the court has promised us that possibly by tomorrow we are going to get a copy of the judgment. Once we have it, we will swing into action. Let me say this. We have to be very, very careful in this country. If we are not careful, electoral jurisprudence will virtually disappear. I'm saying this with every amount of sincerity because when the litigants, when those who contested the election continue to find it very difficult to establish their case due to obstacles all the way, starting by INEC. Certainly they may resort to some other means of trying to seek justice, which may not be lawful. And nobody encourages that. Nobody encourages that.
Alleged drug case, why Tinubu forfeited $460,000 in US, APC tells court. The All Progressive Congress APC has opened up on circumstances that led its candidate and president-elect Bola Tinubu to forfeit the sum of $460,000 to the government of the United States of America USA in 1993. The ruling party processes it filed to defend the outcome of the presidential election that was held on February 25th maintained that Tinubu, who was its candidate, merely surrendered funds in 10 bank accounts that were opened in either his name or that of Compass Finance and Investment Company. It told the Presidential Election Petition Court (APC), sitting at the Court of Appeal in Abuja, that funds in the said accounts, which were domiciled in both First Heritage Bank and Citibank NA, were subject to a civil forfeiture proceeding in case number 93 C4483. According to the APC, the purported decision of the United States District Court's Northern District of Illinois Eastern Division in the said case was not a fine, but a decree of forfeiture of the amount of $460,000 to the United States pursuant to the settlement of claim by the parties to the case. The said decision is not against the second respondent, Tinubu, but against the funds in the various accounts opened in the name of Bola Tinubu with First Heritage Bank and Citibank NA. The compromise terms that led to the forfeiture were preceded by express admission on record that the second respondent did not admit the commission of any drug-related or illicit conduct of dishonesty or fraud that fit into any of the grounds of disqualification to contest for office of President of Nigeria at the 25th February 2023 general election, APC insisted. It listed the 10 account numbers that contained funds that Tinubu forfeited after the settlement of claim by parties involved in the case. Example, 263226700 and others. Besides, the APC, through its team of lawyers led by Prince Lateef Fagbemi San, told the court that the federal government had, as far back as 2003, through the American consulate in Nigeria, inquired about Tinubu's criminal record. It said the outcome of the inquiry, which FG made through the Inspector General of Police, yielded a clean bill of health that unequivocally and unreservedly cleared second respondents of any criminal record, interest, or association in the United States of America. The former clearance report dated February 4, 2003, under the hand of legal attaché to the United States Embassy, Nigeria, in response to the inquiry by the Inspector General of Police, is hereby pleaded and shall be relied upon for its full effect, particularly the portion in the second paragraph which states, in relation to your letter dated February 3, 2003, reference number SR 3000 IGP SEC ABJ VOL 24287, regarding Governor Bola Ahmed Tinubu, a records check of the Federal Bureau of Investigations (FBI) National Crime Information Center (NCIC) was conducted. The results of the checks were negative for any criminal arrest record, warrant, or warrant for Bola Ahmed Tinubu. For information of your department, NCIC is a centralized information center that maintains the records of every arrest and conviction within the United States and its territories. APC said it would apply for a subpoena to be issued again at the IGP to enable him to adduce and tender in evidence. The letter dated February 3, 2003, which triggered the clearance letter of the legal attaché of the U.S. Embassy in Nigeria, as well as response to the same dated 4th February 2003. It further argued that the said forfeiture Tinubu made to the U.S. government having lasted a period of 29 years, was no longer a valid ground to challenge his eligibility to contest the presidential election. The respondent states that in any event, the pleaded decision of the United States District Court, Northern District of Illinois, Eastern Division is not a decision by a competent court of law or tribunal in Nigeria, and same has been falsely, mischievously paraded by second respondents' political adversaries like the petitioners, detractors, and haters to scandalize, demonize, and demarket him to the Nigerian electorate at the 25th February 2023 general election with a view to delegitimizing his well-earned victory at the polls, despite all legitimate and fact-checked denials and rebuttals as exemplified by the official reports from the United States affirming his innocence and exonerating him from the touted drug connection and criminal conviction. The respondent states further that in any event, the said decree of forfeiture was made by Judge John A. Nordberg in the said case on the 4th day of October 1993, a period of 29 years before the 25th day of February 2023, when the said presidential election was duly conducted by the first respondents. The respondent avers that the allegations referred to in the said paragraph have been subjected to litigation and duly litigated upon a court of competent jurisdiction in suit number FHCL CS 1146 1999. The respondent further avers that having been litigated upon by a competent court of law, this honorable court is estopped from retrying the same issues that has been appealed against. The respondent shall found and rely upon the judgment in suit number FHCL CS 1146 1999. Without prejudice to the above, the respondent avers that the Nigerian police force investigated the second respondent regarding any record of criminal arrests and/or conviction.